Civil actions can become very complex and almost always involve money. Similar to criminal law, there are many different types of civil courts used to hear various civil cases. Cases that involve large sums of money are tried in a provincial Supreme Court and may be appealed to a provincial appeal court. Some cases that require important precedences may go to the Supreme Court of Canada. Generally, cases that are relatively minor in nature are heard in small claims court. Often referred to as the People's Court, small claims court resolves civil disputes of $10,000 or less, although some provinces have limits as high as $25,000. The trial itself is more informal, with a plaintiff and defendant representing themselves. Both parties present their sides of the story to a judge and do not need to know much about the law, as the dispute is usually fairly simple. Plaintiffs file paperwork themselves and pay a court fee. The defendant receives a copy of the lawsuit and then a court date is set. Common small claims actions include breach of contract, minor accidents, damage to property, recovery of property, unpaid loans, rent, or wages. In a criminal case, verdicts are based on the concept of beyond a reasonable doubt. In a civil case, verdicts are based on the balance of probabilities, which means more probable than not. The plaintiff and defendant, also known as the litigants, must convince the judge that their version of the dispute is the correct one. The judge must then decide which version or story is more believable. If the plaintiff wins the case, the defendant is liable or responsible. If the defendant wins, he or she is not liable. A plaintiff must begin a lawsuit by filing a statement of claim, which includes the plaintiff's name and address, the defendant's name and address, the amount of money or compensation being asked for, a brief, clear summary of the reason for the claim. A court fee must be paid by the plaintiff, and a copy of the lawsuit is served to the defendant. A civil action must be filed within a certain time of the incident. This is the limitation period. The time period ranges between 2 and 5 years. A defendant has between 10 and 30 days to respond, depending on the province. When a defendant is served with a civil action, he or she has a number of options. First, accept total responsibility and settle a claim by providing a payment in court or settling out of court. Ignoring the claim, if so, a default judgment will be awarded for the plaintiff. File a counterclaim, in which the defendant counters the lawsuit filed against him or her by filing his or her own lawsuit against the plaintiff. Fighting the plaintiff's claim by filing a statement of defense and going to trial. Or make a third-party claim in which the defendant claims a third party is completely or partially responsible for the dispute. In higher courts, with cases that are more complex and involve larger amounts of money, other individuals and mechanisms are brought in to assist the litigants. In a higher court, it is recommended that the plaintiff and defendant retain counsel, that is, a lawyer. An examination for discovery is a pre-trial process held to learn the evidence that each side intends to present in court. Similar to disclosure in criminal law, both sides agree to show each other all relevant types of evidence, for example, documents, photos, and files. Civil actions outside of small claims court can be decided by a judge or jury. In civil court, a jury is comprised of 6 people. Juries are not often used in civil trials. The plaintiff presents his or her side of the story first and is followed by the defendant. Each party then summarizes or provides a closing statement to the judge and/or jury. A decision can be made to grant all, part, or none of the plaintiff's claim. A class action lawsuit is a single legal action that is brought forward on behalf of several people who share a common grievance. Example: in recent years, there have been a number of lawsuits against drug manufacturers by people who claim to have suffered side effects ranging from overdoses to illnesses. In this kind of situation, all people who have suffered from a particular drug can sue the drug manufacturer together and can all be named as plaintiffs. Class action suits put more pressure on the defendants and, if successful, often result in higher settlements.